And so even in a situation where I think some of the best intentions and kind of best policymaking impulses were at play, they all end up being subject to the same kinds of gravity. And that leaves us with the same kinds of public challenges around the protection of that data, around the privacy and related issues that come up. So I'd be interested to know whether that's a theme that other people have seen coming up in some of the other countries represented here. Thank you.
All right, we do appreciate it. And let's cross to Switzerland and try to understand if the narrative is any different. Waterleaks, please chip in a little bit here. He's a postdoctoral researcher. And so that we understand, this side in Africa, Africans are very trusting people. And oftentimes we find ourselves actually willingly giving information with no questions asked. What is the narrative in Switzerland?
Much for the introduction. So I'll be speaking kind of with two hats on, I think now. So first, let me say something a little bit about the situation in Switzerland. So one of the things that Murray just mentioned, right, is do these things go away? And this triggered one thing in that in a lot of the legislation that we have in Switzerland, for example, around contact tracing, there are sunset clauses in place that essentially say this thing will self-destruct after some date in the actually now quite near future. So that is at least something that has been in place and that I think is probably a good practice here. Also, in general, I would say that people here are probably not quite as trusting as they would be in Africa later, right? And where we actually did try to put in relatively strong privacy protections to make abuse more difficult, right? And in that context, as Alexandrine was also saying at the beginning, right, there is a lot of pressure to collect as much data as possible because there will always be people that claim that having more data is useful. And personally, I would call shenanigans on that a little bit. It is highly doubtful that collecting data on millions of citizens is actually going to help you do much better. So I would sort of ask the critical question, one, do you really need all these data? Could you also do with less data? And if you're collecting these data, what purposes are these data actually serving? And maybe that is a purpose that says this could help. But actually, if we're very honest, we have no bloody clue whether this will help or not, which will then inform your narrative about maybe we should actually be collecting a lot less data or about a much smaller subset of people under much stricter constraints. I'll leave it at that for now.
Wow, that is interesting. The reason that some of our organizations or governments are giving for collecting data, that it is very useful. Waterleaks calls it shenanigans, but we want to cross to Niger and speak to the former president of the Municipal District Court 2, that is Mr. Aseni Gado Mawusa. What has it been like amidst the pandemic, big data collections, and of course under the pretext of this is useful information?
Relativement donc à la pandémie, elle n'est pas assez exhaustive pour la simple raison que notre particularité, c'est que l'autorité de régulation a été installée après l'avènement de la pandémie. Néanmoins, dans la loi 2017-28 du 3 mai 2017 relative à la protection des données à caractère personnel, une place importante a été accordée à la préservation et à la protection des données de santé en ouvrant le collège de régulateurs donc à un représentant de l'ordre des médecins, pharmaciens et chirurgiens dentistes. C'est parce que le législateur nigérien a compris très tôt que les données de santé sont très importantes, que cette faveur, si je peux le dire, a été faite aux acteurs du secteur de la santé. Donc, le représentant de ce secteur important de la protection des données personnelles siège dans le comité qui gère la pandémie. Donc, ça, c'était aussi une heureuse coïncidence, ce qui fait que nos rapports n'ont pas été très conflictuel parce qu'en fait, il appartient aux deux comités. Non seulement il est membre de l'autorité de régulation, et il est aussi membre dans le comité qui gère donc la pandémie. Ce qui fait que nous n'avons pas eu du mal à faire passer nos messages. Après notre installation officielle le 20 juillet 2020, nous avons eu à attirer l'attention du gouvernement sur la nécessité de respecter la législation sur les données personnelles dans le cadre des réponses qu'il apporte donc aux effets du Covid, notamment à l'occasion donc des tests et de la vaccination ainsi que de l'hospitalisation. De concert avec l'autorité de régulation, l'attention du gouvernement a été attirée notamment automatiquement détruite lorsque les finalités pour lesquelles ils ont été collectés arrivent donc à son terme. Et nous avons aussi attiré l'attention du gouvernement par rapport à la collecte et le traitement d'autres données personnelles permettant d'identifier ou de localiser les personnes concernées. Nous avons dit de faire en sorte que ces données font l'objet plutôt d'une protection mieux fournie et que cela soit fait par des personnes habilitées, c'est-à-dire pas seulement des personnes, des agents de santé qui sont assermentés. La collecte des données doit aussi se limiter uniquement aux personnes ciblées, donc par les autorités sanitaires. Il ne faut pas qu'à l'occasion qu'il y ait un peu de la tricherie et qu'au-delà, on collecte des données d'autres personnes qui n'ont rien à voir donc, avec la gestion de la pandémie. Autre recommandation faite au gouvernement, nous lui avons signifié de faire en sorte que le traitement des données personnelles relatives à la santé des personnes soit suivi exclusivement par des professionnels. Donc, il faut des professionnels et les professionnels même doivent être des gens sous serment. Et dernière recommandation, de limiter donc aux seules données nécessaires à l'identification et à la localisation. Donc, toutes ces limitations faites au gouvernement, en fait, sont tirées de notre législation, de notre loi, qui a élaboré un certain nombre de droits pour protéger les personnes concernées et à dégager un certain nombre de principes que nous traduisons à travers donc, des délibérations de portée générale. Autre innovation, notre législateur a fait en sorte que, comme à l'accoutumée, comme la plupart des autorités professionnelles, a fait en sorte que les données de santé soient considérées comme des données sensibles. Donc, les données sensibles font l'objet d'une protection.
Mosa is actually saying. And of course, Mr. Hira, if you could do us the honors and translate for us so that we're all in sync. Mr. Hira, our resident translator, you could do us the honors and give us a translation of what Mr. Saini Gadu was actually submitting to place all of us in sync and continue with the dialogue. Well, right now I'm imagining Mr. Hira is still unavailable, but probably at a later minute he will be able to do that. And I want us to go through our second round of questioning. And I'll start from up again. Linda Bonyo from Kenya. A reminder that she's a tech thought leader and a respected tech lawyer, licensed attorney at the High Court of Kenya, that is among other placements. Linda, it is a highly restrictive health crisis that the whole world is actually fighting, specific to the pandemic. If you could speak to us on what you believe or that governments across the world can actually do to respect the fundamental rights and freedoms of people while also collecting data at the same time.
Thank you very much for the question. I think in terms of what governments can do, one is, may not sound like, a privacy question, but I think there's need for governments to enable movement during COVID, and movement across borders. It's becoming more and more difficult to travel, across borders because of we have the vaccine passports that certain countries have put in place. If you're like me and have tried to travel a bit, this few weeks, we have a lot of intrusive tendency happening, which are government sanctioned. So you will have you're forced to take a COVID test in Kenya, and if you are maybe going to Nigeria, then you have to get to Nigeria again and test, when you get to Nigeria and when you're coming back into the country. There's need for governments to speak to each other and then to see ways in which, we don't make travel harder by even having in addition vaccines, in this case. The second thing that I'll talk about would be, I'm so sorry, there's an ambulance somewhere near the hospital, so I really apologize. Okay. So I'm going to maybe just make a quick final statement on procurement of technologies. I think for a long time, there's been civil society engaged in mapping out that are powered by emerging technologies, let's say blockchain technology or artificial intelligence technology, because of the fact that there's a skills gap within civil society sometimes, let's say in Africa, that don't necessarily know how to keep governments accountable while they're procuring these technologies. And so governments must look at how do we prevent vendor lock-in, that we're not tied to one tech company that's providing these technologies for government, but then also two, can we get oversight? And can civil society have a role in asking these questions, that this technology that you're buying for surveillance, this is the effect it has on our population. And also I think finally, what governments must do is to have a very participatory approach towards the changing of laws. And I like the examples that, our colleague from Switzerland gave on having a sunset clause in new regulations, that we know that curfew is going to last this long, because we've seen, for instance, what's happening during curfew, that, people are getting arrested arbitrarily, there's always policemen overreaching their mandates, in that sense. They would come in and search your property even without, a court order. And so having these sunset clauses will help us know how long this particular pandemic, how long the government would last in their interventions. And then also I think it's important then to also look at what if this happens again, because we know there's a pandemic in 1920, and then we have years later, we had this specific pandemic. There's a need to have forward-looking laws that will ideally prepare for the future, that if this happens again, this is how the government is ready to work with tech companies to ensure that they don't supply governments. And we saw this during COVID, where there was a push in the US to stop Amazon from supplying governments with facial recognition, software and equipment. And so there's need to really draw that line around vaccination and testing. Also the employer aspect to it. How do governments change laws that, regulate the employer and the employee relationship? Because there are people who went far, like employers would ask for your status. There are places now in the world where you can't work. There are vaccine mandates, and so you can't work without you saying exactly what your status is in terms of vaccination or testing. So how do we get to this place where we still respect human rights, but then also give freedom of expression for different people in the context? So those will be my comments. Thank you. And sorry for the siren.
All right, thank you so much. That is Linda Bonyo from Kenya, of course, articulating a number of issues there that she believes our governments across the continent can actually do if they start by listening to each other. She talked about the skills gap and also made a point on the procurement of technologies. But some critics have actually said governments rush to procure technologies or acquire these new technologies. She also talked about whether the public is actually included on what the implications of these technologies could be. But as a solution to contain the health crisis, of course, it cannot be ignored. And let's bring in Waterleaks from Switzerland to actually comment on the human rights implications of some of these acquired new technologies that governments across the country rush to procure.
Contact tracing technologies, but by and large, these would also apply to, let's say, vaccine certificates and others. Because what you see from these technologies is that even though the official narrative is that these are voluntary, I think in practice, these are de facto mandatory. Right? There is a lot of pressure from governments, from society to actually be using these contact tracing apps, to be using vaccine certificates just in order to participate in daily life. And this means that any harm that might come from these with respect to human rights really is amplified because of the scale and the fact that people really don't have a choice in using or not using these technologies. And this is a lot what my work focuses around, is trying to identify these harms. And we have been touching on some of these a little bit, but I want to sort of dive into that a little bit more. If you think about sort of these contact tracing apps, right, where really the purpose would be to assist in contact tracing and whose purpose is to essentially isolate or at least test people that have been in contact with people that have already contracted COVID, thereby reducing the spread of this virus, right? And this means that any technology that helps, quote, with contact tracing must somehow embed a lot of social relationships and geographical locations of people, right? Because that is the only way to know whether somebody needs to quarantine or not, right, is to know whether they were close to somebody who was positive or not. And these systems need to really embed a lot of very, very privacy-friendly information, and that raises a lot of flags, at least when you're doing privacy-related stuff, right? Like a lot of us are, that there is a lot of potential for this to go completely awry, right? Like any data that is being collected will be later used for purposes that we did not really foresee, right? And here, this is a heck of a lot of data. So this is one thing that you would be very concerned about, right? And this is would be a clear violation of a right to privacy. Related to that, though, right? Privacy as a goal is very laudable, right? And I mean, I completely support that. But one of the reasons why we care about privacy, right, is the consequences that people are subject to when they lose their privacy. Right? If it becomes public that somebody is gay, or as we saw, or as somebody mentioned just before, right? If it becomes public that they were tested positive for COVID, there will actually be consequences for them in their real life. And so one of the other aspects that you get in particular for these type of contact tracing solutions is that the consequence of being told by such an app, hey, you were a close contact, is that you're going to quarantine, right? So these systems can not only be used potentially to invade people's privacy, right, but also very directly as a tool of control to just send everybody with funny curly hair to self-quarantine for 10 days or whatever is the local regulation, right? So there are definite privacy associated with these, but also sort of harms of control where vulnerable populations can be targeted, or essentially anybody can be targeted. Right? So I think in the case of these contact tracing technologies, we managed to get something that was not quite as harmful as it could have been. Right? But I think sort of circling back to what we said before, right? Like whenever you deploy technology, it's important to not just think about the potential benefits, but also think very critical about the harms that these technologies might bring, either now or as legacy technology in the future, right? Where this technology stays behind, and then the fact that it stays behind will be harmful.
Well, Waterleaks is a postdoctoral researcher that is at EPFL in Lausanne, Switzerland, and with the conversation and expand on technology.
The particularity of Niger as a country, they treated the data collection, the data collection of health information, and it started right after the pandemic. And in that process, they have accorded a high importance to the collection of healthcare data, which were required to be treated as sensitive. The data collection entity actually was regulated by the national committee that handled the whole pandemic in Niger. And it was also a member of that regulation committee which enabled them to treat the data they were collecting according to the law, because they were monitored by the state. And the state, they have also been required to keep the data. They have been given a directive to store and destroy the data after 1 year. And that data was to be collected and treated as a highly sensitive or classified information that could be only accessed and handled by accredited healthcare professionals that had to be under oath. That's how the committee managed to collect the data, the healthcare data of the national population during the pandemic. Thank you.
Well, that is Mr. Hirwa, our resident translator there, trying to place us in sync to what Mr. Saini Gadu Moussa was actually saying of the narrative during the pandemic as governments collected data to inform public health. Now let's cross to South Africa, continue with the conversation on contact tracing approach, and it's commonly been applied as a surveillance tactic during the COVID-19 pandemic. And I want to bring you in, Moray Hunter, on what you think should be the key privacy concerns. Oftentimes, even if it's testing or vaccination, people usually find it hard to ask the questions. They are asked the questions, but they find it difficult to actually ask where this information is going or what it's going to be actually used for. If you're advising in this case, what is key that everyone should actually put into consideration or even worry about?
So the contact tracing technologies obviously occupy quite a large part of people's discussions around privacy and data protection in the pandemic. And just one thing that I should note is that early on in the pandemic, South Africa, like many other countries, was experimenting with digital contact tracing tools like GPS location or mobile phone triangulation, which is trying to track people's physical location within mobile phones. Obviously, as we've heard, there are big privacy implications for that. And like most other places with contact tracing apps, by April, May, June of last year, those attempts had basically been put on the rubbish bin, in the rubbish bin, and the Google, Apple exposure notification approach was the one that was adopted. And we've heard about this. We know that it's really about trying to tell two mobile phones that they're in proximity to each other without actually locating those mobile phones. So it deals with a lot of the initial privacy concerns people had. For me, the bigger question is, to what extent have those kinds of technologies been useful? Now, I know that our conversation is on privacy and data protection, but in the South African, there's very contested research about the extent to which those technologies have really played a meaningful role in slowing the spread of infections. As the model, it obviously was a very effective one, but once it's been rolled out in practice, in the South African case, there have been huge problems with false notifications, people who haven't left the house receiving an exposure notification that someone within 2 meters of them has COVID, but they haven't been within 2 meters of anyone. And it's created some confusion about whether this technology is safe. It's maybe created, in some cases, a false sense of security, in other cases, a false sense of insecurity. And there are real problems with the amount of social capital that was spent in trying to get people to adopt this technology rather than other other public health interventions, because a lot of kind of airtime and public attention was spent on getting people to download this app. There's one thing, but as I said, the technology has occupied a lot of our attention, but the bigger part of data collection was that every time someone goes for a test in the South African context, they're required to write down their details. They're required to write down preemptively then closest contacts, details, phone numbers and names of the people that they've been exposed to in the last, that said, this is a state of disaster that we're declaring for 3 months, and and all of these things will self-destruct at the end of that 3-month period. But COVID lasted longer than 3 months, and that state of disaster has perpetually being extended by another 3 months, another 6 months. And so that's a situation where when that policy was unrolled, it was really welcomed as, a pretty good set of safeguards. But it has ultimately meant that this emergency data collection protocol has become permanent, despite there being a sunset clause. There's one final thing, which is that we speak about the importance of trust of trust in public health and in public life. And what, in a context of the pandemic where there is growing public distrust, where there is public health kind of sort of COVID, people who deny the existence of COVID, one doesn't want to stoke mistrust of government and public institutions. But very often what we're being asked for is not trust so much as faith. And I think it's really, really important at this stage, now that we're looking at a pandemic that has lasted for 1.5 years and may last for a lot longer. Public institutions need to do a lot more to slow down, to review all of the emergency protocols, to disclose a lot more information about lessons learned and failures experienced in the implementation of these different systems, and to bring the public into their trust, and to actually revisit a conversation around all of our public policies around the kind of COVID crisis, including contact tracing. Thank you.
Well, okay, continuing on, one of the first things that Linda Bonyo mentioned about what governments across the continent can actually do was to ease the movement of people during COVID, but at the same time, she pointed about forced COVID tests as you land in a different country altogether. And it also brings into the conversation about vaccines and passports and the global inequity that is becoming more apparent, yet measures such as vaccine mandates or passports are being adopted. Now, the executive director, that is Unwanted Witness, Dorothy Mukasa, please speak to the experiences still in Uganda on how you think such measures have actually affected the communities and what you also think needs to be done.
People might face. For instance, you look at low-income economies that really have vaccines at a level of 2%, and compared to 43% in the higher income economies also enforcing vaccine mandates. This means that we are amplifying the injustices and the barriers that already exist, and the powers, giving more power to the privileged. I'll give you an example recently, just this week, where the Parliament of Uganda, really the clerk to Parliament, issued a directive that every member of Parliament should have a certificate, should present a vaccine certificate before entering in Parliament, and whoever staff that works at Parliament and the visitors who are supposed to get into Parliament. Because of the power that the MPs have, they really stood firm and rejected this, and the decision was overturned. But then students who are reporting, who have been at home for over 2 years, university students have been at home for over 2 years, are now required to go to school. They started going back to university this month, but they're required to present vaccine certificates, and they've been sent away from accessing the university premises because they do not have vaccine certificates. So that speaks to the power, that the vaccine mandate is creating amongst societies. So if you look at the well-to-do university students who are coming from powerful families, they've been able to access vaccines and they've been able to be vaccinated. Now, the poor who are coming from the rural, the deepest part of this country, cannot access vaccines, and therefore they're being denied access to education. So these are the inequalities that are being amplified by the requirement of vaccine mandates. But I also want us to know that availability of vaccines does not necessarily mean access, because we've had over time political leaders talk about the vaccines available, go and be vaccinated, but the reality is that the vaccines are not accessible. We've had in the same vein stories, evidence of different ordinary persons who have moved from one point to another trying to search for vaccines, but they're not available. But at the top, people will tell you, leaders will tell you vaccines are available, but accessibility is another thing. So ordinary people are really being excluded here, and the amplification is real. Bonio talked about the movement. You can't move now if you don't have a certificate. But how many people have access to the vaccines? For example, in Africa, how many in the Western world we are talking about vaccine boosts. In Africa, we're even struggling to get the first dose. And we are actually implementing similar policies like the Western, which is really a disadvantage to the vulnerable communities in our country. So I think as what should be done, I think governments need to ask themselves questions, and it's the right time now to get everybody down to ask themselves whether the vaccination requirements justifies the potential infringement on other rights. We're seeing vaccine requirement infringing on other rights. Is it justifiable for that matter? We need to answer these questions as actors, but also, most importantly, governments, before they really move out to implement vaccine mandates. They also need to ask whether a vaccine mandate does not create undue burden on any section of the population. I've just talked about the inaccessibility of vaccines in the rural countryside, but even in the urban, not everybody has access to vaccines. Do we create a burden to the population that is already burdened? The vulnerable.
That's a good question, Dorothy Mukasa, and I think it would be at this moment very important to bring in Alexandrine, because she's worked at Privacy International, which has analyzed the World Health Organization guidance in detail to at least answer to some of the questions on inaccessibility and, of course, the haves and the have-nots amidst the vaccine mandatories. Alexandrine, according to your reflection, do you think sufficient measures have been taken to consider the implications for equity and privacy?
Thank you, and I'm going to build on what Dorothy's presented in terms of really what would be some of the implications as some of these initiatives are being rolled out around the verification of COVID-19 vaccination status. And before I go into specifically the issues of equity and inclusiveness, as well as aspects of privacy, I think it's important to also think about, what we're talking about here. The vaccination records do play a role in terms of the vaccination programs, in terms of keeping track of who's been vaccinated, and they could help also with further steps of the vaccination programs, as Dorothy was mentioning. In some countries in Europe and elsewhere, we're already, looking at boosters, which would be, a third dose following the first and the second. But I think a lot of what Dorothy was referring to, and she gave clear examples, is that once being vaccinated becomes a requirement, so does the need to verify this record. And that's where it becomes a pass, and that's where it becomes an identity document. And so once you have multiple uses, and we already had a few mention, access to services, in the case of, students as well, accessing educations, and some to be able to access their workplace in terms of being able to stay in their livelihood, but also looking not just, in terms of multiple uses, but also multiple domains. And that's something we haven't discussed as much here, but in a lot of the partner countries that we're working on, it's not only government officials, or public sector requesting this verification, both at the domestic level and, let's say, at the international level when crossing border, but also there are private actors, in terms of having access to restaurants, sometimes to public transport as well. We had examples for our partners in Pakistan where this was then being requested to be able to access banking services. And so really what we're saying here, and was already outlined by a few speakers, is that this approach to both the identification and then verification process has an impact on our day-to-day lives if it becomes mandatory, even though, as Murray, and others were saying, there's voluntary and then de facto mandatory, to, impact various aspects of our day-to-day interactions, be it for personal reasons or professional reasons. So when it comes to really, everything that Dorothy mentioned in terms of how it can impact different communities, whilst it was one of the strong elements of the approach being rolled out by different governments. And I'll give a few examples. For example, in order for the system to be equitable, we really need to remove barriers to access, and barriers to access in the way Dorothy was mentioning in terms of having meaningful access to the vaccines themselves, but also, being able to access the vaccine, but also the requirements that are being imposed by on individuals to be able to access that vaccine. And we saw it in a few countries like India, for Uganda in the initial changes, but also recently in South Africa, in terms of needing to provide an identification document. And in many instances, it wasn't any identification document. It was the document that was issued by the government itself. And that has huge limiting factors for all the, the reasons that Unwanted Witnesses work on ID has shown, people are excluded from accessing a lot and being able to have an identification document. And so linking access.
Alexandra,
sorry.
I should come in there a bit. I know that good point on removing those barriers, and if these barriers actually do exist, and there are those that want to actually litigate such cases on privacy infringements, what exactly should they consider before going to courts of law to actually litigate such cases? And Mr. Seini-Gado Moussa, if you could just chip in there and give us your submission on specifically that. Mr. Seini-Gado Moussa is from Niger and the former president of the Municipal District Court 2 Magistrate.
Merci encore une fois de l'opportunité que vous offrez à la HAPDP de participer à ce grand rendez-vous. L'honneur nous revient d'entretenir les autres panélistes des considérations que les justiciables doivent observer ou doivent avoir avant de saisir les tribunaux pour contester les différentes atteintes à leur vie privée, donc à l'occasion de la gestion du Covid. Donc, effectivement, l'avènement de la pandémie à Covid-19 a profondément bouleversé la protection des données personnelles en soulevant de nouvelles questions et en donnant l'occasion donc à certains praticiens de commettre certaines atteintes donc aux différentes législations en matière de protection des droits et libertés individuelles. Donc, heureusement que les réponses apportées par les différentes législations quand même sont venues renforcer le dispositif existant déjà, parce qu'il faut rappeler qu'au-delà de la protection des données personnelles, il y a déjà des dispositions de droit commun qui protègent la vie privée. Donc, s'interroger sur les considérations que les justiciables doivent observer avant de saisir les tribunaux nous amène surtout à dérouler la procédure. Donc, il faut tout d'abord reconnaître que les atteintes apportées aux différents droits à l'occasion de la gestion du Covid sont pour la plupart des atteintes qui sont justifiées. Elles sont justifiées parce que tout simplement, elles sont faites elles sont d'abord faites par l'autorité publique, donc la puissance publique dans le cadre de l'exécution d'une mission de service public, notamment la mission de service public de santé. Donc, ce qui fait que ces atteintes-là peuvent être justifiées parce qu'elles sont faites dans l'intérêt commun et dans la préservation de l'intérêt commun. Et très souvent, ces atteintes-là ont fait l'objet d'une législation. La plupart des pays ont institué des lois, notamment concernant l'état d'urgence sanitaire. Mais, malgré tout, nous sommes en matière de protection des droits et les justiciables doivent se dire que la puissance publique, malgré les justifications que je viens d'exposer si haut, n'est pas autorisée à commettre certains abus et que ces actions n'échappent pas au contrôle du juge administratif, notamment donc à l'occasion des contrôles de légalité. Mais avant même de saisir le juge administratif, les plaideurs, donc les justiciables, peuvent saisir l'autorité de protection pour les cas spécifiques de violation de la vie privée relative à la protection des données à caractère personnel. Parce que notre législation nous donne mandat de conseiller, de recevoir et de traiter les différentes plaintes que les personnes concernées peuvent en toute matière donc déposer à la HAPDP, donc à l'autorité de protection. Ensuite, le juge administratif, comme je le disais, et le juge constitutionnel peuvent, chacun en ce qui le concerne, être saisis lorsque le comportement de l'autorité administrative est manifestement illégal au regard donc, des différents textes en vigueur au Niger. Il arrive aussi que les atteintes soient injustifiées, c'est-à-dire que les atteintes soient des violations pures et simples du droit à la vie privée. Cela est très fréquent, mais malheureusement, la possibilité de saisir les juridictions ou l'autorité de protection est annihilée par l'ignorance même des personnes concernées. Donc, c'est pourquoi ils sont invités très souvent à venir se renseigner au niveau de l'autorité de protection que nous sommes pour que nous puissions examiner leurs plaintes en cas d'atteinte et voir les différentes possibilités qu'ils ont pour pouvoir saisir les juridictions compétentes. Mais puisqu'il s'agit d'atteinte à la vie privée, souvent même à la dignité humaine, donc il y a déjà un dispositif qui est déjà pris au niveau de la HAPDP, notamment des mesures conservatoires pour peut-être bloquer ou bien freiner ou bien faire cesser l'atteinte.
His submissions relate to the infringement cases and how litigants that actually take these cases to court can be able to consider a few issues here and there before they stand before either a magistrate or a judge. And our resident translator, that is Mr. Hirwa, is going to put his discussion of what he was talking about into perspective. Mr. Hirwa.
Thank you. He was talking about how they handle some attempt to some violation of privacy of privacy data of people who violate the privacy. So the government of Niger have put in disposition some laws that protect the privacy, and some attempt to tamper with the private individual are punishable by the law. The healthcare public is the one that is mostly sensitive and protected by the law. But also for the litigation of those cases, they have to check if the violation was done knowingly or unknowingly, because most of the times, because of the absence of a clear legal framework, those violations are done unknowingly. So they have to establish if it was done knowingly or unknowingly. So when most of the time when it's done unknowingly, they can find a way to litigate it. But when they find that it was done knowingly, then that's how they proceed to go further, like in a court of law or something. But because of those legal framework being new, there is still a gray area between to know if the violations are done knowingly or unknowingly. That is the main challenge, I guess.
Okay, well, thank you so much, Mr. Hiro. A couple of comments and questions have been coming in during the dialogue, and we want to read some of them so that if there are questions here and there, then some of our panelists can actually be able to answer to them before we conclude this particular session, and you also await another session that is coming up. Well, from Aroma Hamza, yeah, sound is good. And hello Jay, kindly post the questions here. All right, and I'm sure they've been forwarded, so I'm trying to look for a question here and there. Jay, is my post with the points 1, 2, 3. I'm trying to see a couple of questions for our panelists for this session. Yesterday they did not answer my questions. Well, I'm reading from some of the comments or questions that have actually come in. Kindly post the questions here. I'll forward them to the moderator. And as the questions come in, remember it is the 3rd Privacy Symposium Africa, and it happens annually. This session is on effects of COVID-19 testing. A question, there's actually a question there. Having sunset clauses for data collected during the pandemic seems right, but is it not too soon to ask for these? And number 2 is, will governments not have a legitimate interest in retaining data for legitimate reasons? I think we should start off with that and see if any of our panelists can answer the first one. Having sunset clauses for data collected during the pandemic seems right, but is it not too soon to ask for this? Probably Alexandrine, is it okay if you could take that on? Alexandrine Pilot de Cobion.
Principles that data should only be collected for a particular purpose, and that is also associated with the need to only, to limit how long the data is stored. And so in the context of the pandemic, we really needed to see that the data processing activities were tied to a specific purpose, and that if they became needed for additional purposes, then they would need to go back to this initial idea, getting consent again and going through this process of ensuring that it still met all of the requirements when it came to data processing. And so this question as to whether it's really soon, it depends whether the government or whoever's doing the processing is able to justify that the data processing needs to keep going for that particular purpose. But I think, as mentioned by various speakers during this session, is that particularly Murray in the example of South Africa, the justification given kept either changing, getting bigger, expanding, and so it leads to this scenario where even though there should have been storage limitation and data processing being limited for a particular purpose and for a particular period of time, the fact that a lot of these decisions and processes have also not gone through inclusive, in the case of Kenya, let's say parliamentary process, but in other countries, different legislative process, but were decided by ministers, it means that those decisions or these safeguards that should have been rediscussed at various stages of the process haven't been discussed. And there was just this given that we're currently still in a pandemic, we need to keep going, but without really thinking about each processing activity and whether they're all needed, that they all needed to be expanded and continued, and really thinking what was needed at different stages of the pandemic. So it's not necessarily that it's too early, but those discussions around suts and clauses and what to continue processing and to store needs to be tied back to the purpose. And if that purpose is no longer there, or if it's changed, then it becomes a different discussion. And those safeguards need to be reevaluated and re-implemented for that new purpose as well.
All right, so Murray Hunter, your works of digital rights advocacy and communications, if you could answer question 2, will governments not have a legitimate interest in retaining data for legitimate reasons? And I think it's also related to 3, which is who should advocacy on these transnational issues be directed at?
I certainly think that governments will always have an interest. The question is whether it will be legitimate or not. It's so important at the stage at which the data collection is before it starts, that there are ground rules about what is being collected and what it will be used for and by whom. And then finally, of course, what the sunset clause is going to be as well. But what I don't disagree with what Jay is asking, but what is so critical is that legitimate purpose, whatever it is defined at the beginning. The people who are giving over data know what it is and they've consented to it. And then the question of where should we direct these issues to? In the African context, obviously, AU bodies is a really important point of call, and the African Commission to start to set some guidelines, or continue to set guidelines rather, that our societies can take the lead on. But there's also obviously the service providers. Now in contact tracing contexts, most of them are not the big ones that we think about when we talk about service providers, telecoms providers or the Googles and Facebooks. But there are a range of service providers that have facilitated very important interactions between public health bodies and citizens, using WhatsApp, using bulk messaging and things like that. Those providers are collecting a huge amount of data in the process of doing those services, and they should be held to the same standards that we would hold national governments to.
Well, thank you so much, Murray Hunt. A couple of questions that actually came into our panelists for this particular session on effects of COVID-19 testing and vaccination amidst the pandemic. It was a very, very interesting discussion, of course, from filling the skill gaps in data collection to procurement of technologies, not forgetting inclusion of the public on the impact of these technologies as they are used, whether in vaccination or actually contact tracing, to easing on the vaccine mandates, since, of course, there are the global inequities in accessibility of these vaccines. The 3rd Privacy Symposium Africa continues, and of course await another session that will be coming on shortly. And as we take a very short break, well, our resident band, that is the Titanic Band, is going to be entertaining. Thank you so much for being part of this session. My name is Mebo Twegumiezake.
Hakuna tabia za kupendeza, siku ya kwanza ni kuona kwa macho. Samu nimekamia, siwezi kutalia, njoo niusie mawazo. kule ninakunywa sawa, sikukuona nikuona pamoja. Sawa nimekamia, siwezi kutalia, njoo nipunguzie mawazo. And I feel you in my air when I breathe. I see you in my life. Uko sawa na wote marahika na mama yangu, wote wanapiga wendo mama yangu. Wewe natakoa sisema, oh baby uko sawa, wote marahika na mama yangu, wote wanapiga wendo mama yangu. Wewe natakoa sisema, hey Isabella, I'm gonna come out and dance with me tonight. The stars look beautiful outside, so beautiful. Tell me I said sorry, I didn't bring you home last night when I was at your house. I know she doesn't miss me. She put on the music, and I like when we go. It does because you're my only concern. Me, I gotta have someone who's a new cut down on your ego. I'm ego. It's my money to baby, because I can't take it when I'm closing. It's tonight. One day I'll be a superstar. We go to kutane gumputura mutima atona dikukagari mutima satanga kagari ikira bina banasi apunta keto processi amezare monanzi alanga lunanzi apoyana nolonchi anzi katiza nyuma
That it's the little things in life that's gonna make me happy. When nothing little grandma told me that it's the little things in life that's gonna make me happy. She said that little by little, feels not the measure.
applause for our resident band, Titanic Band. Thank you so much for that small music interlude. And of course, that was Haba Haba by Stella Mwanji off the album Chinanda. I hope you enjoyed that song. And lots more of that African music will be coming your way. If you enjoyed, please drop a message in the chat room just so that the band can receive your feedback. And I can see messages coming through there. Someone just thanking the panelists for the insightful discussion that we just had. Thank you so much. And I can see other messages coming in, some of the panelists responding personally to the questions that were being asked. Thank you so much. And thank you so much to the panelists and our moderator who did a very, very good job. Now, just to remind you one more time, our sponsors, and we want to keep on making mention of them. Of course, we have NITA Uganda. Thank you, NITA Uganda. Digital Human Rights Lab. We have Omedia Network. We have Katende Sempewa Advocates, and of course from here in Uganda we have the Ministry of ICT and National Guidance. We also have PI, Privacy International, and speaking of PI, our next speaker is actually works and is from the Privacy PI, Privacy International, and she'll be giving us a small workshop or talk, and I'm going to be inviting her in a short while. But again, keep those comments coming. What are you learning? What are the points you need to take back home? What are you going to share back with your governments and your institutions and organizations in as far as privacy is concerned? Now, without further ado, all the way from the United Kingdom, she works with Privacy International, and I hope she's ready in a short while. I'm sure she'll be coming onto my screen. The topic that Lucy Odibert is going to be handling is valid consent. The validity of consent, valid consent, and processing personal data is generally prohibited unless it is expressly allowed by the law or data subject has consented to this processing. And so consent management essentially covers the consistent life cycle from start to finish, all right? From data collection and enabling data subjects to change or withdraw consent, to deleting personal data, to mention but a few. I'm not going to go into the details, but I'd like to know if Lucy is ready to give us that talk. The next workshop we're going to have the next 30 or so minutes. Lucy, is Lucy online? Beautiful. I see you. We hear you loud and clear. How are you doing this afternoon? Well, it's afternoon here in Uganda. I don't know what time it is where you are.
Yeah, it's 1:30, so it's afternoon as well.
Beautiful. All right, so Lucy, I'm just going to hand the ball to you and let you take us away on valid consent. Over to you, Lucy.
Thank you so much for having me. I'm just wondering, can you see my slides up on the screen?
All right, I think we're putting
It's
your
coming
slides up right about now.
Amazing, perfect. So I think you can...
So whenever you want the next slide, just let us know.
Okay, well, next slide, I think that's just a little animation of our logo. If you click, okay, next slide should work normally. There we go. Perfect. Okay, there we are. So thank you so much for having me. I'm Lucy Odibert. I'm a legal officer at Privacy International, calling in from cold and rainy London. So today I'm going to give you a little workshop on valid consent. Can I have the next slide, please? So just to start with a few words about PI, one of the sponsors of the Privacy Symposium. So we're a London-based NGO, surveillance practices. In May this year, we got a judgment from the European Court of Human Rights that the UK's mass interception program that was first exposed by Edward Snowden in 2013 had breached people's rights to privacy and freedom of expression. We also complain against companies who exploit our data for profit. So this year, for example, we filed regulatory complaints in 5 European countries against company Clearview Ai, which is a controversial facial recognition company, which I'll be talking about more later. We also keep track of and analyze the development of data protection laws around the world. For example, we've advised on the development of laws in Kenya or Uganda. And we produce guides to help people around the world take better steps to protect their privacy and their data. For example, the Free to Protest guide, which we published earlier this year and sets out the various technologies that the police can use to monitor protests and how you can protect yourself against these. Next slide, please. So in this workshop, we're going to look at consent with a cross-jurisdictional perspective, since the symposium is a cross-border symposium. So the definition of valid consent that we'll use is the one that we find most commonly in various jurisdictions around the world. So first, I'll show you how consent is really a fundamental element of data protection laws in many countries and places. Then I'll run through a few definitions of consent in those various laws so we can extract some common attributes of consent. We'll then run through these attributes and see what they mean. And then I'll go through a couple of case studies. Next slide, please. So consent is a really fundamental element of most data protection laws and principles around the world. There are no universally recognized data protection standards, but regional and international bodies have created some agreed upon codes, practices, and recommendations and other policy instruments. So I've set out here a few examples to show you how consent is really central to most of these instruments. So for example, the OECD guidelines on the protection of privacy and transborder flows of personal data that say that data should only be obtained by lawful and fair means and where appropriate with the knowledge or consent of the data subject. The famous Council of Europe Convention 108 as well has consent as a central component. Next slide, please. And another example is the Article 8 of the Charter of the Fundamental Rights of the European Union, or the Asia-Pacific Economic Cooperation and Privacy Framework, which requires that collection of data must be obtained by lawful and fair means and where appropriate with notice to or consent of the individual concerned. So you can really see how in these international instruments consent is central. Next slide, please. So I've just put out here also a few examples of data protection laws in some African countries to show you how consent is central there as well. So in Uganda, with the Data Protection and Privacy Act 2019, in Kenya, and in Zimbabwe in the upcoming Cybersecurity and Data Protection Bill, which I think has just gone through Parliament. Again, consent is really a cornerstone of the validity of data processing. Next slide, please. I'm going to go through so a few definitions of consent in these data protection instruments to show you what are the sort of common elements of consent. So the first one I'm using is the European Union General Data Protection Regulation, which was passed, which came into force in 2018, which says that consent is any freely given, specific, informed, and unambiguous indication of the data subject's wishes, by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data. Next one, please. So this is the definition in the EU Protection and Privacy Act, which is extremely similar to the GDPR definition, and has the same opening definition, which is any freely given, specific, informed, and unambiguous indication of the data subject's wish. Next one, please. This is the definition in the Kenyan Data Protection Act 2019, which is very similar. It's any manifestation of express, unequivocal, free, specific, and informed indication of the data subject's wishes. Next slide, please. So as you've seen in those definitions, there's some very common attributes of consent in all these definitions, which are that consent needs to be freely given or free in certain formulations. It needs to be specific, informed, and unambiguous or unequivocal. So now I'm going to go through each of these elements one by one. Next slide, please. Yeah, thank you. So the first one is that consent is freely given or free. And really, this is what we consider the most important and the most competent. Yeah, one more. Yep, thank you. So the first one is that consent is free if there hasn't been any inappropriate pressure or influence on the data subject to provide his consent. So this includes obviously, physically or psychologically forcing someone to consent, for example, through threats or deception or coercion. But in a less obvious way, a very important thing to consider is the imbalance of power between the controller and the data subject. So, for example, public authorities or the state are very unlikely to be able to rely on consent for processing. For example, in the UK, we've seen immigration authorities seize mobile phones of migrants when they arrive in the UK and extract data from these phones. And they sometimes try to rely on consent by stating that they asked the migrants consent for seizing their phone. The problem is that a migrant, when they arrive to the UK, are in a real unequal position and very vulnerable position where they might fear that if they don't comply with instructions or requests, they might be treated differently. So this is a situation where consent is absolutely not an adequate basis for processing data. But there's some situations involving public authorities where it could be appropriate. So for example, if you're subscribing to your municipality's mailing list, then this is something that you're completely free to do. And if you don't do it, there's no negative consequences to not doing it. So that's something where consent would be appropriate. Another context where consent is often inappropriate is the employment context. So for example, it's very unlikely that an employee can freely consent to having surveillance cameras filming them in the workplace. But it can be appropriate in certain circumstances. For example, if the employer circulates a survey about inclusion of LGBT people in the workplace, then that's something that you're free to fill out or not, and therefore consent would be an appropriate legal basis. Another consideration is that you should never be bundling consent with other terms and conditions of whatever service you're providing to the data subject. So tying the provision of a contract or a service to a request for consent, for a request for consent to process personal data that is not strictly necessary to the performance of the contract will make that consent invalid. So for example, if you're requesting a postal address for the delivery of goods that is really necessary for the delivery to happen, because without the postal address, the delivery can't happen, then that you can't rely on consent for this, because the lawful basis will be the performance of the contract. But for example, consent to receiving direct marketing as part of that contract cannot be a requirement to enter into the contract, because direct marketing is not a necessary part of the contract. A very common example that everyone encounters every day, I'm sure, is website cookies. So you can't make access to a website dependent on the person accepting the cookies. So that wouldn't be something that's freely given. It's because you're forced to accept cookies in order to access the website. And finally, you can't have the refusal of consent lead to a detriment for the data subject or any kind of disadvantage. So, for example, you can't require consent to using personal data for website analytics if refusing to give consent will lead to certain functions of the website not working. So really, the freely given attribute is about giving a real choice to the data subject. Next slide, please. The specific attribute means that consent has to be given in relation to each specific purpose of processing. So you can't be bundling consent for different purposes of processing, which means that the procedure for giving consent must allow data subjects to give separate consent for different processing purposes. So if you ask for someone's email address, you need separate consent boxes for the use of this email address for direct marketing and selling that data to third parties. Another element is granularity. So, and this is closely linked to the right to be informed. It means that when you request consent, you should offer the possibility of consenting to certain processing activities, but not others. The aim of the specific requirement is to avoid function creep, which is defined as the gradual widening or blurring of purposes for which data is processed after a data subject has agreed to the initial collection of the data. And this really ties back to the very common principle of purpose limitation, which has been often mentioned throughout the symposium, which says that data collected for one purpose cannot be used for another unrelated purpose. Next slide, please. The informed requirement, first of all, asks that information is provided prior to obtaining consent. And the minimum content requirements of the information that's provided to the data subject in order to enable valid consent are first the controller's identity, the purposes of processing, as I mentioned, what data will be collected and used, the existence of the right to withdraw consent and any other rights that are relevant in your jurisdiction. So that can be the right to erasure, the right to object to processing, the right to access, and any other jurisdiction-specific rights. So, for example, the right to know about the use of data for automated decision-making, or whether, or information like whether the data will be transferred to another country or transferred to third parties. So this really goes to the right to be informed. Next slide, please. And so in order to fulfill the informed requirement, there's various ways in which you have to provide information. The first thing is that the information must be provided in clear and plain language so that everyone, understood as the average person, should be able to understand what you're saying in this information. Also, the key information to how data will be processed must not be buried down in long privacy policies or terms and conditions. If there's really key information to which the data subject is consenting to, it must be separate and clearly signposted, either with red ink or really bold things. So the tricky thing is in providing information really is to balance the need for precision, i.e., giving all the information relevant to data subjects, but also being understandable, so that it's not pages and hundreds of pages of privacy policies. An option to balance this is to provide what we call layered or granular information, for example, with drop down arrows or icons that make things easier for everyone to understand, but at the same time provides all the information that's required. And importantly as well, the information you provide has to be accessible to the people that you're targeting. So you have to keep in mind who this information is addressed to. For example, is your service targeting children? In which case, the information has to be understandable by children. Are people with disabilities going to be accessing your service? And also, which language are your data subjects speaking? So for example, Facebook's privacy policy, hopefully, I've never really checked, is available in all languages in which Facebook is active as a service. Next slide, please. The final element of consent is that it has to be unambiguous. So that requires a clear affirmative act that signifies consent. So that means, and this is something often quite controversial in data protection laws and with abusive controllers, is that consent cannot be implied. You can't just assume that someone would consent to your processing activity. So for example, a lot of websites abuse this and assume that scrolling through a website will mean that people have consented to whatever notice they've put on there. This is absolutely wrong, and you need to have a clear affirmative act. You can't start processing data until you've had this clear affirmative act. Importantly as well, consent can't be obtained through the same motion as agreeing to T's and C's or a contract, so it can't be the same tick box, for example. And similar to the tick box example, the consent journey cannot require intervention from the data subject to prevent agreement to processing data. So you can't ask data subjects to tick out of a box in order to refuse consent. Next slide, please. I've put here some other considerations about consent. I'm going to run through them really quickly. First of all, you must be able to demonstrate that the data subjects have given consent. So usually this requires keeping a record of consent statements. You need to think as well if the consent that people have provided has a time limit. There's no usually strict limit on how long consent lasts, but it will depend on the scope of the original consent and the expectations about which lawful basis you rely upon, and whether it's appropriate to rely on consent. So, for example, don't say to data subjects that you rely on consent when you're actually relying on another lawful basis, and don't change from consent to another lawful basis after you've collected data. And a final note on a concept that exists in certain legislations, which is explicit consent, and is often required for more sensitive processing like health data. In the explicit consent is a tricky concept because it's often rarely defined. But the way we understand it is that all the attributes of normal consent apply, but the standard for the attributes to be met is much higher. So for example, for explicit consent, oral consent, just saying you consent may not be valid, and it may require more than just ticking a box. Instead, sending an email or signing a document would be something that would be more considered like explicit consent, but it's a tricky notion. Next slide, please. I just wanted to mention dark patterns, and I think someone mentioned it in the chat. I just saw a fleeting reference to it. Dark patterns is a concept that's been coined a few years ago, and it's a concept that describes digital interfaces that are designed to intentionally steer users into making certain choices. So in our case, into consenting to processing of personal data. And so the way this can look, I'm just going to give you a few examples. And here I've put on this slide an example of what would be a typical dark pattern that you've probably seen many times before on websites. So the first thing is default settings. So a dark pattern would be to set privacy intrusive default choices, or and hiding or obscuring the pre-selected defaults. So this is the classic opt-in versus opt-out debate, where people can't see that they've already opted it. They've already been opted in into processing personal data, and they don't see how they opt out. The concept of ease as well is making the choice of the privacy preserving option more cumbersome. That would be a dark pattern. A typical example is having to click, countless toggles to disable non-essential cookies app as appropriate. You may be asked to enter your name, email address, phone number, credit card information, or other details to help you with your experience. Next slide, please. Another extract is from the section about third-party disclosure in the privacy policy, which said, we do not sell, trade, or otherwise transfer to outside parties your personally identifiable information unless we provide users with advance notice. Next slide, please. This slide is showing a technical analysis that was done by Unwanted Witness, and which revealed that SafeBuddha was sharing people's personal data with CleverTap, which is a third party providing customer lifecycle management and mobile marketing services. So that you can see on the left, it's very small, but you can probably see the name of CleverTap there. And on the right, what's highlighted is where you can see that the data shared included the user's current and final destinations for the trip. Next slide, please. Thank you. So I'm just going to ask you, as I don't think I can ask questions from the audience, but if I can, please feel free to either put in the chat or shout. But I just wanted to ask the audience if they see any issues in this consent process, in the information that was provided in the privacy policy versus what we see as information being shared with this third party. So here on this slide, I've summarized the various elements of this consent process. So the one thing to note is that there was only one box asking to sign up to terms and conditions in the privacy policy. As we saw, there was sharing with CleverTap. And then I put down just the extracts from the privacy policy, which were relevant. So yeah, I think I'm going to struggle to hear from the audience. So I'm going to go through the analysis that Unwanted Witness and Nita, you have produced of this consent journey. Next slide, please. Oh, sorry, I think I'm missing a slide. Okay, go back. All right, so I'm going to go through the various consent attributes and see how they apply in this case. So the first one being freely given. As you can see, there, we couldn't see exactly that, but basically SafeBuddha had provided no option to opt in to the sharing of data with a third party, but also no option to opt out. So that cannot be freely given consent. Importantly as well, because there was only one tick box, they bundled consent to marketing and analytics, which involved sharing with CleverTap, together with the agreement to SafeBuddha as TNCs, which means that the consumer has no choice to consent to the sharing of this data that is not necessary for the performance of the contract, which is to provide the ride-sharing app. It wasn't informed as well because there was no information about the disclosure to third parties. It only mentioned a potential disclosure with advance notice. And people weren't informed about the extent of the personal data that was collected and shared. For example, they had no way of knowing that data about their final, from and to destinations, the places where they were traveling from and to, would be disclosed. Consent was not specific either because users were not informed about the purposes of processing beyond the purpose of delivering the service. Nor were they informed about the legal basis for each purpose of processing. So in that sense, consent cannot be specific. And finally, it was not unambiguous because the consent to the privacy policy was obtained through the same motion as agreeing to the terms and conditions. So that was a very interesting example of what seemed like a very straightforward application that a lot of people use, but actually had a consent system that was defiant. Next slide, please. I'm going to go through an example that's about a company that collects data about people all around the world. which you may have heard of. They're called Clearview Ai. And they're an American company whose existence was revealed by the New York Times newspaper in 2020. And that collects all faces that it finds on the public internet and runs them through its facial recognition algorithm to create basically a gigantic database of searchable faces. And it then sells access to this database to the police in various countries, who can upload a picture of someone and find matches for this picture in the database, and then link it back to the websites where the faces were found. And usually, obviously, this is used by the police to identify people which they have found on cameras or on photos. What this means really is that if there's a picture of you online, it could be on your social media profiles, it could be on your professional profiles, it can be on YouTube, then it's very probably in Clearview's database. The way we see it is very much as a tool for tracking people both online and offline. And it, in a sense, it's eradicating all sense of anonymity if you're able to be identified just by your face. And it's basically, it amounts to a mass processing of facial biometrics. Next slide, please. So there's been a lot of action against Clearview Ai. Obviously, in the US, where the company is based, the American Civil Liberties Union is pursuing legal action against the company. They obviously, that's where they have most legal standing to be able to take the company down, because the company only operates from the US. But there's been action across the globe as well, and Canada and Australia, privacy regulators have now declared Clearview Ai illegal in their countries and have ordered the company to stop collecting and to delete the faces of all Canadians and Australians. And so earlier this year, Privacy International and other organizations have filed complaints in 5 European countries, hoping that the General Data Protection Regulation in Europe can help us to get rid of this dangerous company. Next slide, please. So I just wanted to show you what the result of a face search on Clearview's platform looks like. This is taken from a data subject access request that a colleague of PI has done last year. So you can see that if you upload a photo, an original search image, as they call it, they will find all photos of you that are on the internet. And below that, they'll have links to where those pictures were found. Next slide, please. So here I've just set out a list of all the data that Clearview collects about people. So that can be, as I said, photos of you that you posted on Facebook, Instagram, etc. It can be photos of you taken at conferences like this one that are posted by your colleagues or by the conference organizers. It can be photos of you taken by journalists at protests where you are in the background of the photo. It can be your name as well if it's associated with any of these photos. For example, on your LinkedIn profile picture, there's your name next to it. And it can be the URL of the website page where the photo was found, which often can have personal data like your name or the place where you are. Next slide, please. So I'm going to run through the consent issues in the case of Clearview Ai. So the first thing to note is that even though Clearview is collecting the faces of most people around the world, most people have actually never interacted with Clearview Ai. So if you're not a police officer, you've never contracted the services of Clearview Ai. Another thing to note is that they collect what is sometimes called in certain laws special categories of personal data or sensitive data, because the way they run your face through their facial recognition algorithm will extract the unique vectors that make up your face, and that's biometrics and therefore sensitive data. There's also no notification it's not often, there is no notification to data subjects that their faces have been collected. And therefore, if there's no notification, there cannot be any information provided. So even though Clearview has a privacy policy on its website, if you're never notified that your face has been collected, you're never going to end up in Clearview's privacy policy. So they won't be informing you of this data collection and processing. And also, if you do end up reading Clearview's privacy policy, they don't actually explain that they'll be extracting biometric vectors from your face and build a searchable database from them. So all these things together mean that consent, there's not even a consent journey, because consent is completely non-existent. And so that raises the question, and it's really the question that is the focus of a lot of the litigation and the complaints against Clearview Ai, is whether consent can be implied by the fact that these pictures are available on the public internet. And that's very often the claim that Clearview makes, is that they're free to collect. And you can't say that consent is unambiguous, because if you upload a picture to social media, that does not unambiguously indicate agreement to the collection of that image by an unknown third party for commercial purposes. And actually, the collection of this information is often forbidden in many social media platforms' terms and conditions. So YouTube, for example, forbids the scraping of information from its platform for commercial purposes. And also, even if this is the case where you upload a picture yourself, but what if someone else uploads a picture of yourself? That in that case, there's no question, it definitely cannot be inferred that you have consented to this picture being here in the first place, and second, being scraped by a facial recognition company. So, and the thing is, even if you know about this, your only option to opt out of this processing, to either consent or opt out to this processing, is by learning about Clearview Ai. For example, through media reports or through this presentation. And then your next step would be to go on their website and to send a request to the company to ask them to delete your data and the faces that they've already collected. So in that sense, you definitely cannot say that consent is freely given, because it's assumed, and then the only way is for you to retract it later on. But also, even if you retract it and you ask them to delete your faces, if there's new pictures of you that are uploaded online, then suddenly they're going to collect these as well. And so you have to go through this process over and over again. So there's definitely no consent in Clearview's practices. There's many other issues to it, but I think the cornerstone of it is the complete lack of consent. Next slide, please. So yeah, this is the end of the case studies. I'm going to ask if there's any questions in the audience. I can't see the chat right now, but if someone wants to run me through questions that have come up. Wait, I think I can open the chat here. So I see a lot of very useful information sharing and link sharing. No, any particular questions? I see a question about UK organ donation, where you have to opt out. This is unfortunately not a data protection question, and I'm not an expert here. I think this would have to be asked from a health professional or someone else with more expertise in that area. I see
I see one question.
Yes.
Lucy, and I'm just going to try and paraphrase, and you can make a comment. Why do platforms like Facebook, Meta, as you like, keep dark user interface patterns when asking for consent?
So I think that's referring to the dark patterns that I mentioned earlier. Yes. And so that's an excellent question, and I think the reason is that their whole business model relies on processing massive amounts of personal data. And so if they weren't to use these dark patterns, a lot of people would actually decide not to share as much data as they currently share. And that would be extremely harmful to their business model, because they would end up with only personal data that is necessary for the performance of the service, which is actually a very small amount of data. And so suddenly their whole business model that's been built over the past 15 years would crumble. This is starting to be acted upon by regulators, and there's very interesting reports from some regulators that I know of in the EU who have been saying that they're going to crack down on dark patterns.
Also know asked the question is actually said he's calling for a ban on this practice. So I don't know how that will go. But Lucy, we want to say a big thank you for a wonderful workshop. Very, very insightful. I mean, after your presentation, I feel I'm so exposed. I don't know. I need to go back and see what to do about just safeguarding all of my information. But there's a few more questions. If you're still online, please just take some time to go through the chat room, and you could personally answer some of those questions. Of course, Jay Sharma asking you medical questions, organ donors, to mention but a few. But I'm sure you'll find some relevant questions in there that you can respond to. For now, we're going to have a small commercial break as our resident band gets ready to take us away. And when we return, we'll be having our last panel discussion. And that panel discussion is going to be on national ID systems, the safety of personal data and the right to privacy. All right. So, and I can see a few more questions coming in. I'm sure Lucy is still online. She'll be answering those. If I could just see the chat room. If I could just see the chat room one more time. I think maybe one or two that I saw. Hamza had a concern there. Let's see, where is that question? He was asking how the human rights data protection really help out on those whose privacy data has been compromised. As I understand, due to our stone-hard government, some programs rise up a mandate. And anyway, I think, Hamza, all of these questions are going to be answered by Lucy, and not just Lucy. Lucy is not the only one informed in this particular aspect. So feel free to chip in, all of you in the chat room, and share your opinions or your thoughts on the same. But for now, over to Lala and the band. What's the name of this song we're going to do? Emlan Jenny, another African tune. Over to you.
That's what me know. I'm not destiny. I need to have a river. I need to have a river. To come and my chance. I need to have a river. I need to have a river. To come and my chance. I need to have a river. I'm talking about Montino ya masibanyo kolio ya kambe beni nazalisa wayo ya motema Tobani mwana tomeseni nayo dunia Tobani mwana chimoni kana miso ya mama Esa mi mapena ya na pasi na zate Kijana ya kuzoya tosa mama kinshasa Mapasa Nakuamo ya kabili Oti wapi Yanimati Mapasa Nakuamo ya kabili Oti wapi Suluka kaponde ko Kwenye bani bomwana kutamole kinyamo kimagana yo Mabasa Nakuro Kusumu Toye bami
The name of the song, Nairobi, special dedication to all of our friends here in East Africa, particularly in Kenya. And we need a song like that for Kampala. In a short while, I'm going to be introducing the moderator for the next panel discussion. And like Samson Kasumba said yesterday, all Africans can sing. All right, so I'm going to dare Mildred to make sure she joins the band as she gets onto the set for the next song. Lala, do you have a simple song that you think Mildred can sing along to?
Yes, we have it.
What do you have in mind?
I think let's still...
Or should Mildred request one that she can sing along to Mildred?
Yes.
I hope you don't embarrass me on national TV.
No. This is international TV.
No, international TV.
Yeah.
Just sing something. Let me see if I can be able to get along with
that. Okay. Let's still live and die in Africa.
Live and Die in Africa by Sauti Sol, right? Yes. Beautiful. Let's go. Come on.
gonna go down in history. Make my mama proud.
I got the berry.
Oh yeah. Ani aliyamani.
Hey, feel them oh, no place for the go. Oh na na na, oh na na na. No place for the go. Oh na na na. Even time in Africa. Yeah.
It started before the music reaching my toes. Come on, come on, come on, red. Hey! Live and die in Africa. Thank you so much, Lala and the band, the Titanic Band. And who knew that my moderator for the next panel discussion could actually sing and dance as well. Before we turn this into a party, let's first get back into serious business. So Mildred Haise is a...
Wait, Ronnie, it's okay.
It's
okay
okay.
To party. We've been locked down for how many?
For long.
Too long. We can't wait for January. Here in Uganda.
Yeah.
In Uganda, we can't wait for the president.
Promising, that's the problem. So we're waiting.
It's okay, promises are dead. We'll keep counting down.
All right, so the party will continue even after this panel discussion. We'll be getting Mildred Pan the dance floor. And wherever you are, you can also join us with some sweet African ballads from our wonderful band. But like I said, Mildred is going to be moderating a panel on national ID systems, the safety of personal data, and the right to privacy. You know, I should ask you before I let you take over.
First of all, do you have a national ID?
Absolutely, yes, I certainly do. You know, and I'm actually concerned. This happens to me all the time. Just 2 weeks ago, I went out with a team down to Burundi, trekking gorillas, and you know, because the permits have different prices, international and local prices. And so they asked me to submit the national IDs, pictures, the front and the back of all of the IDs of the people I was going to be going on this tour with. And I was just a bit concerned because all of our data is there, our names are there. How safe is all this information just, you know, being put out there in the public?
And you know the most biggest problem is, but first of all, you're going to Burundi in this COVID era. You're the way to do family.
All right.
People
stick to the topic.
Okay, no worries. Very good question.
Yeah.
You've seen instances, and I'm talking about a Ugandan scenario where, you know, those papers that you've printed out, somehow they end up being wrappers for chapati on the roadside.
Exactly.
And anyone can be able to access you've seen people's CVs.
Yes.
Used to wrap chapati. So it's a question, a very good one, about privacy. For me, mine using the ID was on agency banking. No qualms with agency banking.
Yeah.
It's convenient and everything. But at the beginning, it was a necessity for you to write your NIN.
All right.
In that book. So for all the
NIN being your national ID number.
Yes.
Yeah.
So for the many times I was asked for my national ID, I wasn't sure. I kept asking myself, what if we lost that, you know, the book? How safe it is. You've seen how people photocopy and forget a copy, one of the copies at a photocopy.
So it's not a clear copy, they put it aside, but all the information is there.
It's still there.
Yeah.
Very, very bad to say, but and people's information ends up being misused.
Yeah. And that's exactly what we're going to be getting into right now. I mean, I see some people posting pictures of their national IDs, front and back, all the information on social media, and maybe we need to be educated and enlightened on, you know, safety and privacy when it comes to national ID and ID systems. So I'm going to leave Mildred, or Millie, like we call her back here, to in your capable hands to take us through this panel. Over to you.
Thank you. Thank you very much, Ronnie. And I hope you are doing well. I wish I could get a shout out from the people who are online, but I mean, we need to get now into the serious business. The discussion on data protection. I posted on one of my handles and said, the more we have sought for convenience, the more we've become exposed. There's so many applications you download, food app, transport app, dressing app, whichever application. And many of these keep asking for your information. They're asking for maybe you, and your online buying as well. You're exposing your information there. Not to say that it is bad, because that's where we are going with the fourth industrial revolution. We're using technology. But the question is just how many of us pay attention to even the data privacy policies that we are asked to agree to and sign. You know, I normally remind people that it's like loan signing. For some of us in Uganda, you just ask, where do I sign? You don't even go ahead to look through the data privacy agreements that you get to say agree to before you can proceed, just because you're rushing up so much. So I have a great panel that's going to be breaking down these, the precedents that have been set in Africa, and we want to be looking at those. My name is Mildred Tuhaise, and I'm glad to be your host this afternoon. Without any further ado, allow me to introduce to you our session panelists, and starting with, in no particular order, is Barry Mamadou, and Barry is going to be representing, of course, It's a beautiful, beautiful space. Anita Uganda, thank you for coming through on supporting and partnering Privacy International, Ministry of Information, Communication Technology and National Guidance. Katende and Sempe were advocates, and of course, our organizers, the Unwanted Witness. Now, I'll first of all take an overview of all the panelists on what they think about these national ID systems and what they mean for data protection and privacy. And allow me to start from Ghana, from Teki. Teki, if you are able to hear me, just in about a few minutes, your overview of these national IDs. It's a mass rollout. The governments have asked every citizen to get their national ID because that is your show off. Every time that you're asked, can you be able to introduce yourself, you're able to show off your national ID. But what do you think about them?
Thank you very much, Mildred, and thank you to the organizers of this symposium for inviting me. Clearly, the issues of national identity or provision of national identity is very important. Some of the reasons that have been canvassed for their adoption include the need to be able to appropriately target and provide government services. And this is extremely important. However, at the beginning of these discussions, though there was, an idea about the risk of that the collection of large data, such as national ID data, can cause to, citizens. And I'm saying there was that mindset was there because if you look at a country like Ghana, even at the onset of the adoption of laws that facilitated for, that advocated for national IDs, there were provisions around data protection. What we tend to see, however, is that in practice, a lot of the state implementers of national IDs, for some strange reason, are hiding under the state apparatus and saying that they are somehow exempt from the implementation or compliance with data protection laws. And for civil society individual, but to the entire database that is being developed, if we do not put in place the adequate data protection frameworks in order to protect the information that we are collecting. So across board, yes, there is the idea that, yes, it is important to protect personal data. However, in implementation, we are not seeing a lot of efforts going into ensuring that data protection laws are properly complied with, whether by the technology service providers or even the government agencies themselves that are working with the technology service providers to ensure that they meet some of these gaps. Key among these areas are especially issues around extra use of the data outside of the original purpose of the data. So the information is being shared for other purposes, and citizens are usually not made aware of some of these purposes. Sometimes some of these information is also shared without the necessary parameters to ensure that the information that is shared is adequately protected as well. We've seen risk around making sure that we are collecting the minimal information necessary to provide this national ID services to people. So there are situations where government agencies are collecting large sums of information and not necessarily adhering to minimality requirements under the laws. We also tend to see situations where when it comes to putting in place adequate security safeguards, governments may not, or the technology providers are not taking into the kinds of data that they are collecting, they are not putting in place adequate security to ensure that, you know, the information is appropriately protected. So there is the mindset to provide, you know, some kind of data protection. However, we have fallen short when it comes to implementation of the requirements of data protection laws.
Thank you. Maybe from that, I would say for the Christians, they would say we've fallen short of the glory of what exactly the main aim for this data was. Let me come to you, Mr. Olumide Babalola. Aspects of human rights in the national ID systems that are being introduced, that are being advocated for by not only the African countries, but even the international community worldwide. What are some of these human rights aspects that ought to be looked at? Because for any citizens of Africa, you're just asked, I mean, you will need to register for this, you will need your national ID to do this and that and that, but we're never given a chance to pay attention to the aspects of human rights.
Partners who have come together to organize this event. It's very timely, and I've followed the discussions, and they are quite apt to what we're experiencing these days on the continent and other parts of the world. Thank you very much. So anytime issues of digital identity or identification comes up, first of all, the issue of dignity of human persons is always thrown either away or not even addressed at all. Like the data subjects do not even matter. You want to identify us. Sometimes you say it is for security purposes. Sometimes you say they are for economic considerations. Sometimes you say they are for the purpose of national orientation or for whatever purpose that the government comes up with. But what about the dignity of the people to be identified? What happens to what they feel about the mode of identification? What happens to how they feel about how their data is used? Just like Teki mentioned, how it is managed, how it is secured, how it is shared. No explanation whatsoever in most cases are given. And when those explanations are given, they are not even quite impressive or satisfactory in most cases. Another thing is that of privacy, and that is, it keeps coming up. It keeps coming up for every a country. In Kenya, we've had the Huduma number situation. I understand it's now kind of appeal. Apart from the issues surrounding inclusion, what about how these data are used? And what about how secure they are? What about how they expose citizens to privacy invasion? I mean, what are the explanations around giving consideration to all these issues that data subjects might raise? So privacy is also another human rights issue. The freedom of expression. We've seen in the past that you cannot even criticize, you cannot even analyze, you cannot even advise the government on how best to go about this identification procedure. In Nigeria, we've gone to court against the National Identity Management Commission. And in September, we had a decision from the Court of Appeal, where the Court of Appeal actually emphasized that such procedures impact data protection. And it's the first decision in Nigeria on data protection, and we still keep celebrating it. But aside the fact that it has something to do with data protection, what about all the obligations of these organizations or these government agencies handling people's data? So in the past, we've had serious issues of privacy breach. We've had serious, for example, in Nigeria, the application, the software that is meant to be used by the commission was put on Google Store and all these app stores, and we found out that they were not even secure, because once you put in your own details, what you find is another person's details. We also went to court to challenge that. So aside dignity of human persons, we have issues of privacy breach, and most importantly, we have freedom of expression, because you cannot even naturally approach the government and say, okay, so the way you are going about this thing is not the right way to go about it. This is what, because we are the victims. We are the victims of any identification system, and the Nigerian situation has shown how privacy continues to stare us in the face. and how much they have not given so much attention. I understand that's the second question, so I won't really go so much into it. So for me, dignity of human person is a serious issue that national identification systems have not taken into full consideration. Privacy is a serious one as well. And when we begin to talk about inclusion, we begin to talk about some other rights too that concerns data subjects around the world. Thank you.
All right, thank you very much, Mr. Olomide. I think back to you. I think you mentioned a very, very key aspect of the explanation. It could be a good system that's coming in place, but just how much do governments get to explain this for a buy-in, a very positive buy-in from the citizens? And these allow me bring in Brian Kira. Brian from, yes, right here in Uganda. We know the story of how the national IDs came through and, the first resistance that people got until they realized, oh, you need a national ID to be able to access some services or be able to do some stuff. Now, Brian, let's talk about, first, even before we look at exclusions therein, let's talk about the human rights issue, because it simply looked like a forceful thing, forcing it down the throat of Ugandans. After all, it was, or it is, government which was driving it. Brian?
Thank you very much, Aldred. And indeed, I'll just pick it up from what you said. Some of the red flags that we also really had were around government's aggressive push for the rolling out of the national ID. And you would think that if it was truly the best thing that could have ever happened to Uganda, then the uptake would equally be as fast. But then we had challenges there. And what we've seen is that government was aggressive on it, but on the other hand, we also saw that the system is intrinsically flawed. So because of this, you'll find that right from the onset of registering for the national IDs, the way the system was laid out, you had to move certain distances to be able to get registered, and then there were numerous delays in actually getting the national IDs. There are even reports of older persons and people generally of all ages that could not be able to input their biometric details. All this was only pointing to one thing. We got a system that I think as a country, we were not ready, at least not to aggressively push like that, and more so to start pegging it to key social services like health and social assistance. I know that many of the people that are in the more urban areas like Kampala will find this very strange to their ears, but out there in many areas, to access a public health facility, you actually have to present a national ID, and there are cases of people that have been chased away just because they do not have a national ID. So the situation is getting there, and yet we see government being hell-bent on using it. The national ID has literally become a gateway to access to social services. And I think that is very absurd. And also just to circle it back to what one of the panelists was saying from another jurisdiction, that you'll find instances that you are aggressively pushing for the rolling out of the national ID. But at the same time, there isn't enough explanation or justification that is given to the people that are being sold this. So in many instances, you'll find that when you ask a person why they are accepted to sign up for a national ID, all they'll tell you is, well, government requires us to do so. And that is it. At best, another person will tell you that we were told that without a national ID, you will not be able to vote. And that is pretty much it. And now, years down the road, you find that now the government is saying for you to be able to go to a health facility, you have to present it. For you to open a bank account, you have to present it. For you as an older person to be able to access your monthly allowance, you have to have a national ID. And so things become complicated at that stage. And that is how we're seeing issues of exclusion popping up. I will definitely be delving a little more into this when I next have the chance to speak.
Oh, yes, definitely, Brian. You will have a chance to speak about these exclusions because there's sometimes things we don't get to think about. Let's move on to neighboring Kenya. Before we even talk about the precedent of what the High Court nullified, Mr. Kanso Ekai, let's look at how ready Africa was or is for such mass rollout of national ID systems. And are we even looking at human rights aspects, or we are just picking on something? Well, there are advantages to it, but are we carefully scrutinizing the process of rolling out these national ID systems?
Thanks a lot, Mildred, for that question. Yeah, so the story of national ID systems in Ghana, in Nigeria, in Uganda, in Kenya, and everywhere is the same. I mean, listening to friends from Nigeria and Ghana, I get the feeling that that is exactly a copy paste of what happened with the Huduma number in Kenya. And the Huduma number case may be a classic example of how, a government may try to force down the throats of citizens, and regardless of how to oppose it as citizens. I mean, if the government wants to force it, to you, I mean, they just put it to you and force it to your throat, and that happens. So the Kenyan experience was a bit unfortunate because we were told through the media that the government is planning to roll out something which will be called the Huduma number, and that Huduma number will be, one, kind of a one-stop shop. Like everything is there. Everything the government wants to get about you is there. I mean, be it you are the Kenya Revenue Authority detail on what exactly the Huduma number was intended to achieve. So some people who are later labeled as, conspiracy theorists are beginning to say, oh, this thing is satanic. The government is trying to dig out, some information about, I don't know what, who is evading tax. There was no clear education of the public about the particular government plan and rollout. So with that in mind, you will imagine, what the ordinary citizens in northern Kenya, in southern Kenya, in the forgotten corners of the country, who only wait for, what Nairobi implements and they just rubber stamp it. You can imagine what was in their minds, when even those in the city were very confused. So human rights activists led by the Kenya Human Rights Commission decided to go to court to challenge, number one, the legality of the rollout of the Huduma number. So it's called the National Integrated Identification Management System. It's called NIMS in full, but it's famously called the Huduma number. So people went to court, citing various legal loopholes which existed in that particular rollout. Number one, there was no adequate public participation by the government to the citizens on this particular rollout. And that is a breach of the law because the law in Kenya requires that, for every government action, for every law, every legislation, there has to be, a meaningful participation of the public in that particular process, so that the citizens who will be the people that will be affected by this particular law or rollout or program actually are part of it. Otherwise, you'll be accusing citizens that, oh, ignorance of the law is not defense. But I mean, are you really being fair to the citizens by imposing something which they have not participated in? So that was part of the reason why the people went to court. And then number two, and this was very key. So the petitioners cited the lack of a data protection law in Kenya to safeguard the data and all the information that will be collected from the citizens. So the High Court appeared to majorly agree with the petitioners, and they said that, I mean, much as the government was right to roll out the Huduma number. And in fact, since I registered for my Huduma number close to 2 years now, I have never got it. Some of my friends have got it, but I have never got it myself. So even going into the next election, we are not even sure whether we are going to vote using our, normal ID cards, or we are going to vote using, the Huduma number. The government had mentioned at some point that by next month, December, every Kenyan will have a Huduma number, and then they will phase out the old ID systems. That is not happening anytime soon. In fact, we may the latest we will have the Huduma number may actually be, maybe 2025. I don't know. That's just my estimate. So that calls, into question the legality aspect of the whole process, the procedural aspect of the whole process, the substantive aspect of the whole process. So there is a need to make sure that before you venture into such an initiative as a government, do you have a data protection law in place? Do you have public participation having been undertaken so that all stakeholders are on board? So that and many other, considerations will determine whether or not a rollout such as the Huduma number, which is now becoming a classic example of how, government rollout, may be injurious to the public, at least procedurally. So that discussion, I think, is key. So thanks a lot. Back to you, Mildred.
All right, Councillor Benyo, thank you so much. It's an interesting discussion. I followed that happening in Kenya, and I was just jaw-dropping and asking, what does this mean for the other African countries with such? But I'll be coming back to you, Council, of course, to get that. Our next presentation will be going all the way to Niger, and we will be hearing from Barry Mamadou. But Barry as well, before we even look at how the ID systems can functionally prove their importance in African countries, I also want to get your brief overview. You've looked at what has happened in many African countries and how these ID systems have actually been implemented by the different African governments. Do you think we are on the right path? And do you think aspects of dignity, human rights are being encompassed in these rollouts? Mr. Mamadou.
Thank you, merci beaucoup de m'avoir donné la parole à l'occasion de ce panel qui est très important. Par rapport à la question du système national d'identification qu'on voit un peu partout en Afrique, les inquiétudes sont un peu partagées, sont les mêmes. Et souvent, on peut se demander quelles sont les réelles motivations, souvent des bailleurs qui sont derrière cette identification des personnes. Parce qu'au Niger, on a 2 projets avec la Banque mondiale à travers le projet Ouri qui vise à réformer le système d'état civil et d'attribuer un numéro d'identification unique aux personnes. C'est que le risque, c'est la catégorisation et surtout les risques d'atteinte à la vie privée, à l'usage malveillant qui en sera fait, et par rapport surtout à la collecte et au traitement des données, mais également à leur hébergement. C'est vrai, le Niger, la phase est en phase d'initiation parce qu'on avait lancé les TDR récemment, on a fait appel à la consultation internationale pour essayer de voir. Néanmoins, quand même, des inquiétudes subsistent par rapport aux multiples sources d'identification et surtout un problème d'interopérabilité de ces sources. Parce que on ne sait pas si ces sources sont enregistrées, où est-ce qu'ils seront hébergés, est-ce que sur le territoire national ou bien à l'étranger. Mais également, il y a un ancrage institutionnel parce que les données sont recueillies de manière éparse et il y a également un problème de texte juridique. Heureusement, il y a la haute autorité de protection des données à caractère personnel, c'est-à-dire qui veille à ce que le traitement de ces données puisse être conforme au respect des droits humains et à la réglementation en vigueur. Seulement lorsque ces traitements sont mis en œuvre, notamment dans le cadre étatique ou dans le cadre du gouvernement, on demande un avis à la haute autorité. C'est vrai, maintenant, on avait attiré l'attention des partenaires par rapport à la question de la sensibilité et surtout aux questions de droits de l'homme. Et cela peut être utilisé si les faits ne sont pas conformes, ça risque d'être détourné. Pour exclure certains groupes, par exemple des gens lors de l'identification par rapport aux questions électorales, on peut voir, ça peut aller au fief qu'on peut considérer comme l'opposition, mais également dans le cadre de la lutte contre le terrorisme. Parce qu'on a beaucoup de partenaires extérieurs qui interviennent et souvent qui ont besoin, qui demandent ces données des citoyens nigériens. Donc, si on n'encadre pas cette utilisation, vous voyez, le risque est grand parce qu'il y a une population qui sera catégorisée et qui seront identifiées par rapport au respect des droits humains, par rapport sous prétexte peut-être de lutte contre l'insécurité, etc., etc. Donc, je vous...
Much better what the discussion was. So please do not be worried at all. Honore, if you can, please, kindly in a few minutes, can you be able to let us in on what Mr. Barry said?
Yes, the question was if we are on the right path in respecting the human rights, if this process of collecting data for national identification. And Mr. Barry started by thanking you guys for welcoming him to this conference. And he thinks that the national system, also in Niger, they also share the same concerns because they are they are concerned about the real motivations of the state. And they have talked about the need to give away 1,000 IDs. There's a project of giving away 1,000 new IDs to the population of Niger that is in partnership with the government and the World Bank. But for them, they have raised a concern of the risk of privacy violations on the way those data are collected and they are stored, because now the initiation phase started. The concerns were about the sources of identifications because they couldn't verify the authentications of those sources, and also they couldn't guarantee the safety of the storage. And also another problem was the legal framework that wouldn't conform with the respect of the human rights during the process of that data collection. So when those concerns were raised, that's when they came in to address them, and they referred to them HAPDP for further guidance, especially on human rights. Also, another concern is that that system can be used during the voting process where a certain amount of the population is singled out based on are they for the opposition or the party on power, or there are also international partners and organizations that are requiring those data. So the concern remain on the accessibility. Is it really stored securely? And there's also the consent. Do the population want all their data out? So those are the main concerns that they have with that whole system of national identification. Thank you very much.
All right, thank you very much, Honore. Broke it down perfectly well for those who probably could not be able to get the discussion that Barry did get. But Barry will be coming back to look at probably the solutions, how these national ID systems can actually serve the promise in Africa. But let me first of all get back to Teki. I think in every African country, there are a number of other pressing needs. The health systems, social systems like health, the infrastructure, and so many others. There's so many pressing needs, feminine inclusive. The question that has come up, I think, in almost every African country, when such mass rollouts are introduced, the question that many ask is, who exactly is pushing these, and for what particular reasons, when we have so many other issues that are pressing us as Africans? I would like you to respond to this question, Teki. Why the push, and who exactly gains in us having all this information captured by the government?
It's an interesting question. One I would not profess to have an answer for. But clearly, what we're calling a push is coming from a number of sources, and there are a number of reasons that can be reasonably attributed to those requests. You would realize that a lot of our countries have, over the last, let's say, maybe 2 decades or almost 2 decades, been looking at the role that ICT plays in enabling socioeconomic development. Now, a lot of the government services which are required to be provided using these platforms require some form of digital identity, so to speak. And so if you're typically a government that is putting in place IT or technological infrastructure to enable socioeconomic development, you are a government that is trying to use technologies to enable development and deployment of government services. One of the key things that naturally follow has to do with giving people access to these services. And so, of course, the first question is, first of all, how do you even rightly identify the people and provide them with the digital tools that they need, including a digital ID that will enable them participate effectively in the service. So those are some of the push that is really where the communication is coming from. Also, Africa is one of the countries and it's one of the continents. And if you look at our countries, a lot of people are unaccounted for, which also affects decision making. If you even look at, even though we've had civil registration structures in place for a long time, there continue to be a number of people that do not have birth certificates, that do not have any form of IDs, which also means that if you're rolling out public services, then a lot of these people are likely to be left behind. So that is also what is pushing for it. Of course, with these opportunities there, and especially in a continent where majority of the technology providers are not necessarily based in our countries or on the continent, then you have to also look at it as opportunities have been seen business, and it is right. And we also see donor agencies and funding organizations such as the IMF, such as World Bank, because of the critical role they play in facilitating development of the economies in our respective countries, also sometimes pushing and requiring some of these things are put in place. I will not say that developing a robust national ID system is very distinct from all the other needs that we have in our communities, such as providing for health sector, providing for education, and the like. In fact, they can be synonymous in a way, and if deployed properly, it can actually enhance, the provision of some of these services. So I wouldn't say so much that we have so many needs that these things are not important. However, the reasons that we have seen and tend to create that impression is because in the deployments, there's not a lot of transparency around it. And sometimes it comes across as if the overall interest of countries are not taken into consideration. And when I say interest of the countries, looking at our peculiar environment, looking at our abilities to access these IDs, whether they are digital IDs and the like, how expensive are these IDs going to be? Can majority of the citizens have access to some of these things? Some of those are not taken into consideration, and then it really plays the whole issue out of context, because then eventually we are spending huge amounts of money on these systems, which sometimes, in Ghana's case, for instance, we've attempted rolling out national IDs for several decades. For a decade now, every time there's a new government, there are new opportunities, new systems are created, and it creates a lot of challenges as well.
Okay. All right. Thank you very much, Teki. I'll be coming. Let me first go back to Kenya. In East Africa, Kenya has been a blueprint of so many things that have happened. And, many African countries and East African countries learning from the Justice Maragas on cancellation of elections. And now we have Justice Jairus, who did say, no, Huduma number, it is not justified, it's contravening the Constitution. But to you, Council Nabenyo, what does this mean, this cancellation mean to other African countries with such in place already? Because maybe many African countries may not have the likes of the Katiba Institutes coming out to challenge such coming through. What lessons? We would like to know what lessons, but maybe I will be coming back to you in that regard. Council Nabenyo, I think we just lost you, but we'll be coming back to you. Let me get back to Nigeria. Babalola, let's come to you on whether these ID systems are actually designed with privacy in mind. For government, there are a number of examples of, you're having to photocopy your ID and give it to a particular firm for something. Then later on, you'll find it being used as a wrapper for selling chapati or something on the roadside. That means a person who is not supposed to get your data actually has it in possession.
Thank you very much. So these are realities all faced in different countries. Yes, they happen. I have also seen the time I bought something along the road, and the wrapper was actually a bank opening form with somebody's picture and name on it. So, these things happen. Now, the government initially is never, anywhere in the world, is never really concerned about privacy when coming up with ID systems. First of all, they are looking at the economic gains. They are looking at tools to identify people. They are looking at tools to aid their surveillance systems and their processes or their intentions. Question is, what does privacy even mean to people in government or to government? They don't care about it. We've seen that happen over time. Today, we just got a judgment from the Federal High Court in Lagos State, in one of the states in Nigeria, and it was about an economic plan. Well, looking at it, it looked like a program that aims at bettering the lives of citizens in terms of giving them small and medium scale loans or funds. But we look at the privacy implications of this. You apply for it online. They would ask for what we call, just like the Huduma number in Kenya, we have what we call BVN here. We have NIN in Nigeria. They would ask for it. And when we approached the court, we were concerned about the privacy and the security of this procedure of the system through which they get all this personal data. And the government couldn't come up with an answer. Rather, they were technical in their approach. Answering questions as basic as who is your data protection officer, they couldn't answer. For example, Nigeria's National Identity Management Commission, just yesterday, before this event today, I checked their privacy notice on their website. And I was surprised that they were referring to a non-existent law as the basis for collecting data. They did not even refer to the Nigerian Data Protection Regulation. Yes, it's a regulation, it's not a principal law yet, but at least it's to a large extent regulate data protection in Nigeria. They didn't reference it, rather they referenced a bill. It shows that they really did not give these things serious attention. If you ask them what are the ways in which they secure the data they collect, most times they can't answer. If you ask them who they share with, they can't give you specific answer. The one that was really ridiculous was on their privacy notice, they agreed that rectification is a right, is a data subject right. Yet, they said they are going to be asking for fees for people to exercise their rights. So for me, government around, especially in Africa, they hardly put privacy into consideration when they are setting up these things. For example, even you want to look at the information security systems of all these processes, they are not top notch. I mean, so much of loopholes, so much of data breach, even at the point of execution. In our own case in Nigeria, when they decided to put all those apps, I said that earlier, when they decided to put all those apps online, put the apps on Play stores and the app stores that we have, if you use it, then you're sure that somebody else is immediately accessing your data, your full sensitive data, your name, date of birth. They don't even know what that means. I mean, to start with. And take it up about the legal framework. That is the beginning and end of privacy. Before you can say you want to give privacy serious concern, let us look at the laws. Let us look at the remedies. Let us look at the approach, the procedures to ventilate rights. Let us look at the punishment for data breach. Let us look at the enforcement network, the enforcement framework. All these things do not exist. I mean, recent last month or about 2 months ago, I think, in Senegal, we launched a report on data protection authorities in Africa. And while we were working on that report, Africa has not done well at all. I mean, we have not done well. I mean, first of all, you can't even access this report online. If you look at all these data protection authorities that exist, you look at what they have done in the past, you can't even see their report. How many people have been sanctioned? How independent are they? Yesterday, it was interesting listening to the Kenyan Data Protection Authorities CEO. I give credit to Kenya. I mean, in the few 6 months or about a year that they have started, they have done so much. But how independent are they in the true sense of the word? How independent are they? Can an appointee of the government sanction the government for data breach? The government pays your salary. The government appointed you. I mean, Teki can relate. She can relate to that. I mean, you are appointed by the government, and you see the government breaching citizens. I mean, we have that in Nigeria several times. So we'll take them to court, and they'll tell you their hands are tied. I mean, you see the government itself breaching citizens' data, yet the DPS cannot do anything. So where there are no framework, where do we even start enforcing these rights from? You go to court, and you try to seek redress, and they tell you, you know what, the framework that should even help you seek this redress are not there. I've taken so much of the time, but I think Africa, we need to begin to look inwards and begin to set, first of all, political will is very important. Is the government even willing to enforce this thing? Thank you very much. Thank you very much.
Babalola, I think you're speaking the bitter truth. You're speaking to the heart, but that is the reality. Well, there are some countries that would say, oh, we have a data protection committee and stuff like that. But I like when you ask, can you bite the hand that feeds you at the end of the day? A very clear one. I'll be getting back to you later. Let me come back home. Brian, when we look at these rollouts and government enforcing, we many at times think, oh, it's all inclusive. Everyone has been included in this. Are there any exclusions really to pay attention to? And if there are exclusions, for example, in the data, national data systems of Uganda, what are these ones and how can they be dealt with?
Yes, thank you, Mildred. And indeed, we do have these gaps. We have exclusions that have been largely occasioned, as I'd said earlier, by the dysfunctions in the national ID system. And to start with, I would like to reiterate and say that we carried out research together with Unwanted Witness and the Center for Human Rights and Global Justice from New York University. And some of the things we were probing into were, is the national ID really, is it living up to its promises? because one of the key promises that were made with the rolling out of the national ID was really around social inclusion. And with this research, we found that this is not the case. Far from it, and this can even be gotten from government data, the exclusions, you'll find that a third of Uganda's adult population does not have. The sectors that we saw these exclusions coming up included one, in the health sector, but then also two, in the social assistance sector. And particularly, I would like to speak to the social assistance grants for empowerment program, the one for older persons. You'd find that much of the time, many people were being excluded because one, they were either not able to move to the registration centers because they could not foot the costs, transport costs, just transport costs. There are people that could not meet them. Others would tell you the lines were so massive, I could not make it, I'm old, I'm frail, I could not be there, and so they left. Others simply told you, I went there, I was told to submit my fingerprint, and the machine could not capture it, and that person was chased away. And then we also had instances of errors that were being made by registration officers. You find older persons going to register for national IDs and the registration officer is a child that is of let's say 25 years. And this older person comes, and the only way she can verify her personal information is through stories. You ask her, how old are you? And she will tell you, I was born about the time when Kabaka Chwa was reigning. And now a 25-year-old will not know when that is. So they will keep guessing and saying, oh, let's give them 60. So you find a person that is over 90 years and qualifies for the social assistance grants for empowerment that is supposed to be given to 80 years and above, older persons. And that person cannot get it because now the registration officer noted that you are 60 years of age. And so these are the challenges. And what makes it even absurd is that when you try to rectify those errors, that is also yet another process. Many times people just give up. And imagine, already people in the urban areas, those that are literate, find it hard to go through that process. Now, if you found a person from the rural areas that is illiterate, and you tell them that in order to do this, you have to go and swear some affidavit or a deed poll, or you have to have this gazetted, and in addition, you have to be paying 50,000 Ugandan shillings, that person will say, I would rather not do this because all this is prohibitive. And that is me not mentioning some of the other unofficial costs that come with it, because you've had stories of people going to these centers and they're told, if you want this to be done, you'd have to oil a few hands here and there. That is still money that is being paid. And so it is becoming very hard. And so the exclusions, unfortunately, are also extending to the health sector. And so in the health sector, and this, I'll just give a story, one of the most absurd stories that we came across when we're doing this research. We chanced upon a pregnant lady who had gone to a health center somewhere in Kayunga. And she was in a dire state. She was literally bleeding. And so when she gets to the reception, they do ask for a national ID. And she says, I left it at home. In truth, she didn't actually have one. And so they told her, you have to go back, get that national ID. So she moves out with the sister, and they just chance upon a boda man, a motorcyclist, who has his national ID. So they either wanted for the pregnant lady or the husband. So when they come back with the cyclist's national ID, it's at that point that now this lady is able to get the medical attention that she was seeking. So it is really gruesome. And I think government needs to restructure and rethink what the benefits are. The cost-benefit analysis really has to be had again, and not only in terms of the financial, but also in terms of human rights, because we are seeing many of our citizens being pushed further down into undignified lives. And I think it shouldn't be so. And some of the things that we've been encouraging the government to do is one around, just stop making it a requirement that for you to access social services, you have to have a national ID. That is the only sole requirement. Mildred, you'll agree with me that before the national ID came, we were having, and we still do have, other forms of identification. These have been used before, and we've seen governments still do this. When we pushed back, when they were requiring that for you to get vaccinated, you have to present a national ID. When we reached out to government through the courts of law and said, you cannot do this, you very well know that many Ugandans do not have a national ID. They reversed that policy and they said, we can accept any other forms of identification that you can have for you to access this vaccination. So why is it that we cannot do this, at least until we are sure that our system is devoid of flaws? But if we continue pushing for it as it is, we are going to have very many people being excluded from access to healthcare, from access to social assistance grants of empowerment. Some people think that the 25,000 shillings that is given to these older persons is nothing, but that is a lifeline for very many people. Getting it on a monthly basis is a big deal. So we need to iron out all the flaws we have. We need to have NERA restructure itself. And I think we've all seen, the media has been awash with many of these stories when distribution is being had for these SAGE grants. Very many older persons cannot get them because of the same reasons. So we really need to rethink the national ID and pegging it especially to social services.
I agree with you, Brian. I totally agree with you. And that's the very reason why we had extremely low numbers at the beginning of vaccination, because it was the only prerequisite that you needed. We need to be wrapping up this panel, and I just feel like it's just started. But let's cross over back to Niger and speak to Barry. Mr. Barry Mamadou, let's look at what Africa needs to do to ensure that these ID systems actually get to meet the promise and meet their function for which they were introduced. What does
Afrique, je pense qu'il doit être conçu exclusivement dans l'intérêt des Africains, afin qu'ils ne puissent pas constituer des menaces pour la sécurité, tels que l'habit, les différents problèmes qui ont été soulevés par les précédents panélistes. Donc pour cela, il doit être conçu assez que de manière qu'il préserve la vie privée des citoyens. Notamment, il doit respecter des principes directeurs de la protection des données personnelles. À savoir, d'abord, il faut qu'il soit légitime. C'est-à-dire qu'il faut que les personnes qui sont identifiées puissent donner leur consentement. Et il faut que ça soit également licite, en ce sens que cela ne doit pas être détourné à d'autres fins, c'est-à-dire telles que l'exclusion d'une catégorie de population, comme cela a été relevé par les différents panélistes. Et également, il faut qu'il respecte aussi la finalité. Il faut que ça soit pour une finalité bien précise, que la collecte ou l'identification est faite, et qu'il soit vraiment également proportionnel et qu'il soit exact. Ensuite, il faut qu'il respecte aussi, je le disais tantôt, le principe de confidentialité. Il ne faut pas que les agents qui ne soient pas autorisés puissent manipuler ces données, les vendre, etc. Et qu'ils soient également sécurisés et qu'ils obéissent maintenant aux problèmes de conservation. Et là, je suis particulièrement exigeant là-dessus par rapport surtout à la conservation sur le continent africain. On ne peut pas permettre à ce que des données des Africains soient recueillies et que ça soit hébergé à l'extérieur. C'est-à-dire cela va poser un problème de souveraineté et surtout de risque d'atteinte. Donc il faut qu'au niveau continental, qu'on puisse réfléchir sur la question, au moins qu'on puisse avoir un data center continental pour qu'on puisse héberger nos données et que cela soit confié à des personnes d'une propriété morale, et comment on appelle ça, d'une probité morale incontestable. Et il faut que le système puisse être aussi pérennisé, c'est-à-dire que ça puisse faire l'objet de traitements ultérieurs dans le cadre. Par rapport aux personnes concernées, il faut aussi que les personnes qui sont identifiées, dont les données sont recueillies, il faut qu'ils puissent avoir l'information nécessaire, qu'ils puissent dire non, qu'ils puissent rectifier et qu'ils puissent demander également la suppression des données qui sont périmées, etc. Donc, en résumé, je peux dire que le système doit être conçu d'abord, il doit être inclusif. C'est-à-dire il doit garantir un accès universel à toute personne sans discrimination, éliminer les obstacles qui ont été cités, les risques d'atteinte aux droits humains qui ont été énoncés par les différents intervenants. Et aussi, il faut que ça soit établi sur une base fiable et que ça obéisse vraiment au but qui a été cherché. En résumé ou en somme, pour dire qu'il faut que ça soit vraiment fait dans l'intérêt exclusif des Africains. Et il ne faut pas que le système puisse être utilisé à d'autres fins, contrôler l'immigration, comme on voit la plupart des politiques qui sont menées sur le continent vont dans le sens, ou bien...
Now be having a quick wrap up from Honore Hirwa for those who probably did not get the message that Mr. Barry and Mamadou was speaking about, and especially with regard to what African countries need to do to ensure that these ID systems speak to the promise they have in Africa as a country. Honore, please take it up.
Yeah, thank you. For the system to keep their promises, it has to be conceived with exclusively African people interests. In this case, we are talking about the system that is done in African countries. It has to be able to preserve the privacy of citizens, and it has to follow the principles of the data protection law. It has to be based on consent of the subject and follow legal framework. It should not be used for further means most of the time which are legals. That system, for it to be functioning in the right way, it has to serve for a clear and concise purpose. It has to be exact, no ambiguity, no nothing. It has to also respect the confidentiality principles, which means the data are handled by professional agents that, if necessary, sworn members of a committee. So that will guarantee the security, and it won't be used for commercial issues or other things. And another important thing was that this system that contains a lot of data of African citizens should not be stored outside of the continent, mostly for sovereignty purposes, because there might be an interference of outside agents and erase a question for the sovereignty purposes. So if it's for African, let it be done in Africa and stored in Africa. Then moral authorities should be the one, moral authorities which are people that are incorruptible, that cannot be corrupted, should be the one who be in charge of the system. Also the subjects that give out their data have to access to their own information, and if necessary, they have to be able to edit the infos in case they find mistakes and everything. That would be that is also a comment he made. Also in brief, so the system has to be inclusive, without obstacles, and with a basis that is trustworthy, and is stored on the continent, and is handled according to the data protection law, and not used for any other purposes, whether political, whether for immigration or for the evolutionary studies. It has to serve for the purposes which the data was collected for. Thank you very much.
All right, thank you very much, Honore Hirwa, for giving us that quick wrap-up of what Mr. Barry Mamadou actually spoke about. And I wish we could have more hours to be able to discuss this, but unfortunately we have to be wrapping it up. A special thank you to you, Madam Teiki Akwete, for joining us on this panel discussion. And of course, that was all the way from Ghana. Send our love to Ghana, and well, probably should be coming to Ghana for some fabric pretty soon. And also a special thank you to Mr. Olumide Babadola from Nigeria. I need to learn some dance, Nigerian dance pretty soon, and I should be coming over soon. A very special thank you to Alex Kira. We're here. We should catch up on some coffee pretty soon and speak about some of these issues and have you hosted as well. And of course, we lost Mr. Ekai, Okanso Ekai Nabenyo from Kenya, unfortunately. But Mr. Barry Mamadou, thank you so much. Key issues that came through, if I could be able to wrap up, of course, some of these ID systems, the government is looking at economic gains, like Mr. Olumide Babadola did talk about, and as a tool for surveillance, unfortunately, and looking at issues of enforcement frameworks of data protection. Are they there? But how strong and independent actually can they be? What are the repercussions of infringement on this data, and how are these followed up? In Africa, or in Uganda particularly as well, we've talked about issues of having the black and white, but the implementation becomes the problem across many African countries. We've also talked about, Brian raised this, stop making national IDs a prerequisite, like the most top prerequisite, for example, for access to social services. And many key issues that were raised by Mr. Barry is, let's have, for example, I would say, African solutions for African problems. If this is meant to be solving African problems, let it be perceived here, developed here to solve the problems here, and please let this data remain right here for sovereignty so that it doesn't get used by people who are not supposed to, and also clear purpose. Privacy should definitely be a key aspect as we develop these systems. A special thank you to you, all our panelists, and all of you who are joining us online. It's been a pleasure. I want to believe that Unwanted Witness will still give us a chance as well to speak to many of such other issues as we continue to seek for, aspects of convenience, forgetting that privacy is put at risk. So, ladies and gentlemen, I want once again to invite our Mr. Hype Man, that is what I will call him, and that is Ronnie Abasa. Back to you. I hand over the mantle, instruments of power.
No, you just stay right there. First of all, I want to say a big thank you to our moderator. I think you've thanked everyone else, and you did a splendid job. So, round of applause from the different panelists. You can, exactly. Thank you. I think you did a good job, and you were very articulate and enabled us to understand the discussion very well. Well, friends, that's about all the time we have for today. And what we're going to do, since you said you want to learn how to dance some Nigerian music, I don't know if Babalola, I can't read from here. Babalola.
Yes.
Maybe you should stand up and
if you could stand up and teach us
give us a move or two. Yeah. He says no. Ask me about national IDs, but don't ask me to dance. No. And I can see Brian worried about the same. Well, ladies and gentlemen, we want to say a big thank you. Our panelists, if you're still there, I think there's some comments in the chat room. Feel free to, just check them out and drop a response or an answer to the different questions and concerns there. But as we bring day 2 to a close, I'm going to invite some of the team from behind the scenes to join us on the dance floor. And I'll ask the band to give us some music. Come on, guys behind the scenes, just join us here. Let's just close the event in some style and swagger. Let's go. Come on. Behind the scenes people, where you at? Olumide, you can dance from there. Look, let's shake your head.
This is another story, from a one. Look at you what they have to do. All these people party inside the bullet. I will go with my best friend, Bullet in there with the papa and Chile. Get your band on my life.
Where am I behind the scenes people? Come and join us.
I just don't want to
girl and she loves the other two on the dance floor. Come on, come on, AJ boys, that's my lights up to win. Almost see the way. Come on, come on. My influencers on the dance floor. Come on. That's what I hold on tight. Hold on tight. Hold on tight. Hold on tight. That's what I hold on tight. Come on, come on. Hold on tight. Hold on tight. Ivan Vaku Kamera stop pretending on the dance floor. Come on. Thank you so much, guys. You've done a brilliant job. Mary Jane, I'm high on life, wanna meditate. So allow me, make my joy life. I'm sweating on the finish road. Every day a different life. Running on the finish road. I just wanna party every day. I just wanna party every day. So pass me the touch it. Come wine for the touch it. Gentle come wine, me the touch it, touch it, touch it, touch it, touch it, touch it. Pass, me the touch it. Pretty girl come wine for me touch it. Gentle come wine, me the touch it, touch it, touch it, touch it, touch it, touch it. As the shut up and bend over. Hey, let your bugger do the talking over. So back up and bend over. Let your bugger do the talking over. Say, I want to show my life. I want to be happy. I want to dance and party. Feel the rhythm of body. Skiddy biddy biddy da da dee da. I just wanna party every day. Skiddy biddy biddy da da dee da. I just wanna party every day. So pass me the touch it. Pretty girl come wine for the bucket. Gentle come wine me the touch it, touch it, touch it, touch it, touch it, touch it. Pass me the touch it. Pretty